So you've got this massive corporation suing a former employee. On the surface, it sounds pretty straightforward, right? But what happens when the sworn testimony, the very thing that's supposed to get to the truth, just creates this huge fog of confusion and, well, sudden memory loss? We're about to dive into a lawsuit where the real story isn't just in what people said, but in everything they wouldn't say.
Right out of the gate, you can just feel the tension in the room. Little exchanges like this one between the lawyers. I mean, it tells you right away this isn't some standard, polite disagreement. This is a high-stakes fight, and it really sets the stage for a legal drama where every single word matters.
Okay, so to really get what's going on here, we need to know who's who in this legal battle. You've got a corporate giant on one side, and on the other, a single salesman. This is their story.
So, in one corner, you have ADP. We're talking about a global powerhouse in payroll and HR, with all the legal firepower you can imagine. And in the other corner, David Schwartz, a former sales rep. It's got that classic David versus Goliath feel, for sure. But the real drama is in what they're accusing each other of.
Let's kick things off with ADP's side of the story. They're the ones who sued first, so they fired the first shot in this whole thing. So what exactly did they say Schwartz did wrong? Well, ADP's case was built on some pretty serious claims. They said Schwartz's sales numbers were terrible, that he was trying to build a rival business while still on their payroll, and that he was emailing confidential client info to his personal account. But the biggest one, the real bombshell allegation, was that he actually forged a client's signature on official paperwork. And to back up that claim about his performance, boy did they have some testimony. In his deposition, that formal testimony given under oath before a trial, Schwartz's old VP of sales, Javier Falla, did not hold back. He flat out said that for the last few months Schwartz worked there, his sales were basically zero. But this is where the whole story just takes a massive turn. See, Schwartz didn't just deny what ADP was saying, he filed his own counterclaim. He didn't just play defense, he went on the offense, turning into a whistleblower with some really explosive allegations of his own. And this is the absolute core of it. Schwartz claimed there was systemic wrongdoing happening at ADP. First, that the company was pushing its regular sales reps who weren't licensed for it to sell really complex financial products, like retirement plans. And second, he alleged there was a common practice of ADP employees signing official state tax forms for their clients, which is a huge no-no.
And in this moment from one of the depositions, you actually hear Schwartz himself directly asking an ADP witness about that very specific allegation, about employees signing these critical tax forms. This question right here really sets us up for the pattern of evasive answers that was about to come.
So this brings us right to the depositions themselves. This is where lawyers, and in this case Schwartz too, are supposed to uncover the facts under oath. The whole point is to get clarity, right? Well, what they got was pretty much the exact opposite. As different ADP executives and investigators sat down for their depositions, they got hammered with questions about Schwartz's claims. And pretty quickly, a very distinct, almost rehearsed-sounding pattern of answers started to emerge. First up, you had this wave of memory loss. When ADP's own corporate investigator, a guy named Gregory Coles, was asked about key documents from his own investigation, his memory just failed him. See, in a deposition, saying "I don't recall" is this perfectly safe answer. You can't prove someone is lying about not remembering something, but it slams the door shut on that line of questioning. Then you have Christiane Roman from Associate Relations. She was asked if she had even read Schwartz's counterclaim, the document at the very center of the case. Her response? "I'm not sure." I mean, wow. This is coming from a key person in the company's internal investigation. And that same VP of sales, Javier Falla, when he was asked about specific meetings and conversations about Schwartz, it was the same story. "I don't recall. I'm not sure. I don't remember." It just became this recurring chorus, this wall of non-answers to very specific, very important questions.
But it wasn't just people forgetting things. There was something else going on. A second pattern started to show up: the constant strategic use of legal objections. It was a near constant stream of them, and they often stopped witnesses from having to answer the toughest questions at all.
This slide is a perfect example of what I'm talking about. A simple, direct question: did ADP talk to any experts about this? And immediately you get object to form. It's a common legal move that basically challenges how a question was asked, not what it's about, but the effect is the same. It blocks the answer. And this happened again and again and again.
And this table just lays it all out, doesn't it? It's incredible. Just look across the columns. You've got the investigator, the VP of sales, the head of compliance, all from different departments, and their answers on these critical topics are basically identical. It's a cross-company pattern of not being able to remember a thing.
So, where did all this lead? After all those hours of testimony, what was the outcome? Well, instead of getting clarity, the depositions just led to a total stalemate. Both sides were dug in, and the truth was buried somewhere in the middle.
The very legal process that was supposed to shine a light on everything seems to have done the complete opposite. The really serious allegations at the heart of this case are still just buried under this thick fog of people claiming they can't remember and lawyers shouting objections. The central conflict, totally unresolved.
You know, the entire point of giving testimony under oath is to create a record of the facts. But when that very testimony seems carefully designed to hide the facts, it forces you to ask a pretty big question. In a legal system that's built entirely on words, what happens when those words are used not to find the truth, but to bury it?